Hi, good afternoon, everyone. This is Rajiv S. Khanna from immigration.com, the law offices of Rajiv S. Khanna PC. Today is July 11th, 2019, and this is our bi weekly telephone call for the community. As you logged in, you would have heard what the preconditions are. This is not meant to be an attorney client relationship establishing conference. We are just trying to do the best we can with the information you give us. So don't take this to be the truth according to gospel. We have limited time and limited information. First question from AT. A Tulk. I wanted to check if you could help me. My wife changed her status to H1B from H4. So she was for last 4 years on H4 EAD, and then you got her H1B approval beginning October 8th of 2018 to September 2021. She hasn't switched to H1B yet. Her current H4 EAD will expire in September 2020. Okay. We used now. The problem is we are basically confused about the timing and when we should make the change to H1B status. We have the following questions. Will she lose the H1B visa if she doesn't use it before September 2021? So the idea is that if I have an H1B approved for 3 years and I don't quote unquote activate it, would I lose it? And the answer is we don't know. Nobody does. We don't think you will. But according to the USCIS incomparable wisdom, they say that an H1B is not complete unless you obtain either a change of status, for example, H4 to H1 within USA, or an H1B visa stamp, for example, going outside USA, getting a visa stamp and coming back. So you have to quote unquote activate your H1B. Do you have to activate it within a certain period of time? There is no such law. Ultimately, unless you get the H1B visa or change of status, you are still subject to the H1B quota. That is their wisdom. I have my doubts that's the correct interpretation of the law, but until they are challenged in court and they lose, we are stuck with their interpretation. So question number A is, will she lose the H1B visa? And the answer is no. We don't think so. B, is it possible to apply for H1B extension by March 2021? Now there are several levels of problems in law. Primary problems we can resolve by just looking at the law. Secondary problems we can resolve by knowing the policy and practice. But this is a tertiary issue where there's neither policy nor practice, no law on this issue. So all we can do is make guesses. I believe that government could come back if they were to follow their own interpretation of H1B quota regulations consistently. They would say, until you get an H1B visa stamping, you are still, or H1B change of status, you are still subject to the quota, so therefore we won't extend this H1B. Would they do it? I do not know, but that certainly would be logical. So what should you do? If you want to stay on the H1B, it's a good idea to convert to it when you can, as quickly as you can. Will she be able to recapture the time she hasn't used for H1B? Yes, of course. Until she converts to H1B, activates her H1B time is not running. So it's the same principle that H1B doesn't begin until change or until visa stamping. So if you extend that principle further, obviously they cannot hold me to the H1 time periods until I actually activate it. Okay? Any follow-up questions on this issue, press *5. No new questions, just follow-up. Okay, today I didn't have any frequently asked questions. Okay, there is one. And this one is from area code 346. 346, go ahead, please. Area code 34.
Hello.
Yeah, go ahead. I can hear you.
Yes. Hi, Rajiv ji. Thank you very much for taking my question. On just follow up on that question. So one of the things that I was confused about, or I've read recently, is the delay that is involved in the H4 EAD processing.
Mm-hmm.
And so it's been taking more than a couple of months for people who have applied recently. So in case, if it is possible to apply for it, early next year sometime. So the thing that we're confused about is whether we should, you know, try to maximize the time uh, on H4 EAD, and then that's in that way we get to keep more of H1B time
No,
in our hand.
no. I
Uh,
I would probably, again, this is a judgment call. I would probably want to convert to an H1B rather than stick on with an H4. But before we do that, let's take a quick look at the strength of the H1B. Is she working at a client site or in-house?
In-house.
Okay, good company, established company, big company.
Yes.
What does she do?
She's a business analyst.
Okay, what are her degrees?
An MBA from a U.S. institution.
Any focus on the MBA? Any particular major?
It's project management.
Okay,
In the
okay.
project management in general.
Do you know what her
So it's
H1B?
not really like programming. Not
Okay.
really programming. It's more about looking at the business side of a company that is involved in IT.
So more like operations, would you say?
Uh, yes.
Okay, these are difficult H1Bs to predict because it's like an operations analyst or operations consultant, business management consultant type of role. Difficult for me to predict how it is going to go at the consulate. All the more reason to try it when you still have time on the H4 EAD. So, one of the things you could do is make an appointment in a consulate in Canada or Mexico. Typically, they tend to be a little faster, perhaps a lot faster than India. So try to get her appointment and get her H1. If for reason that is denied, you can always come back on H4 EAD while you fight out the H1 or reapply under the next year's quota. So if I were you, I would want to apply for an H1B visa as quickly as possible.
Okay.
All right.
I guess I see all the points that you're saying. I think that would be the right way to go. I
Mm-hmm.
really appreciate the input,
You're welcome.
Rajivji.
You're welcome. Good luck to you, sir.
Thank you.
All right. Bye bye.
Bye.
Okay, let's go on to the second question or third question. Prasthak says, I'm currently on H1B. While coming back from vacation earlier in December last year, they issued an I-94 good till 12th December this year, even though it should have been one more year. So, can I stay till November 2020 stamped visa? No, sir. You have to go with the date on your I-94. So yes, you can go to any of the neighboring countries and come back. Make sure when you return, you get a new I-94. In fact, there are there are several places within the USA where you don't even have to cross the border. I know we recently sent somebody to a place in Texas. Look at the Customs and Border Protection sites. I forget what they call them, but you can actually go to one of those places and just get the I-94 reissued. I know for sure that at the Mexico border, CBP has a program where without going to Mexico, they will issue you a 994, an I-94. I think they charge like $5 or $10 processing fees, something like that. So look into that. But yes, your stay in the United States is governed and is legal only to the extent of your I-94. Okay? Any follow-up question on this? Press star 5. No new question. Follow-up questions only. Any follow-up question on this? Okay. This one is from Pennsylvania. Pennsylvania, go ahead, please.
Hi Rajiv, when you say we can go to near Texas for the I-94, still do we need to get a visa for Mexico or not needed?
No, see, the one that I was talking about, this process actually does not require you to cross outside the USA. They do it within USA.
Okay, just drive to the border and then
do some
border security force will just stamp it and give it back to you.
Do some
I-94.
Do some fact finding. I know that we've sent 2 people in the past few weeks. Both have had no problems. Your situation only. In one of these situations, actually, the I-94 had already expired, but not over 180 days. So they were able to get the I-94 again. I think the one that I sent the people to had the name Eagle something in Texas, Eagle Crossing or Eagle Bridge, something like that. Customs and Border Protection. Do some digging into the CBP facilities and you'll be able to find the information that they can actually renew your I-94 without you having to go outside US. Okay?
Okay, thank you.
You're welcome. Good luck. Next question is Krupa. I am a resident of USA residing in Dallas, filed I-130. Why is my I-130 sitting in California? And the problem is government has this work redistribution program. That's what I'm guessing. That seems to be a reasonable guess. They distribute their work amongst different centers, and your application might have been a victim of that. I don't think there is any documented method of transferring it back to Texas because this is an internal procedure. However, I see no harm in at least asking either a congressman's intervention or asking USCIS customer service if the matter can be transferred back. But there is no set and hard process through which you can ask for a transfer back. Star 5 if you have a follow-up question on this. No new questions, please. Star 5 if you have a follow-up question. Okay. Let's go on to, by the way, somebody had posted some questions about political asylum. I'm sorry, we don't process political asylum cases. I have done only one in my life in 1993 and never again. And I did that as a favor. So my knowledge of political asylum laws is close to zero. Our work is primarily in legal immigration, employment-based, business-based immigration. Next question is from Muhammad Jassam. Mr. Jassam says, I'm currently on F1. I started working for company A on OPT and that expired in May. I've applied for STEM OPT extension, which is being now processed for over 90 days. During the first week of May, I got into Big 4 tech company. Let's call it company B. Okay. H1B got picked up, which is currently being processed for over 60 days. I decided to get my H1 from company A approved and then get it transferred to company B. So you have 2 H1Bs going, I assume. But then the manager in company A got information that I was going to leave. I was sure that I am going to stay for another 6 months and then leave if all the paperwork for me to work at company B is in order. Otherwise, I'll just continue working at company A. And the manager was okay with that. Based upon the above scenario, I have a few questions. Using premium processing, if I get my H1 from company A approved in next 15-20 days, what is the earliest date I can get the H1B transferred to company B? You can apply for it right now, but remember one thing. If your company A revokes your H-1B before October 1st, you would still be subject to a quota. Company B said they can send you to Canada. Yeah, Canada and L1 visas are great, especially if they're L1A visas. It looks like you're just getting out of school. You may not be able to get a managerial or executive level job. I'm just guessing, I don't know what your situation is. But if you can get an executive or managerial level job, get an L1A. Going on to EB1C based green card is very lucrative. So the way it works is you go outside USA, work for a branch of this company, and I'm being very approximate in my statements because there is a lot more to the relationship. It can be a branch, it can be a parent, it can be a sister company or a department or a division. So the idea is that you're working outside USA for a US company's branch. After 1 year, you become eligible to come back on L1A or directly come on green card, or first come on L1A and then get green card. And the green card is under EB1C category, which is great. So if that is an option and you can depend upon company B, I would definitely consider that very carefully. See, H1 activation doesn't require you to get any number of pay stubs. All it requires is for October 1st to come and go. On October 2nd, you could join the other employer. I heard that H1B transfers can fail, doesn't matter how big the company. Yeah, they can. But if you have the right degrees and the right job, I have not had much problem getting approvals. It's just a lot more work than it used to be. But before we file the case, we make sure that the job description is appropriately used, that we are not understating or overstating our case, properly documented. So far we've not had any problems. Do you have any suggestions that I could use to get this whole mess sorted out? I think you should stick with company A until at least October, first week of October, and thereafter you can then transfer to company B, or if they are doing another H1B for you, you can use that. I don't know what the posture of the company B's filing is, but I think sticking with the same company, company A, for at least until past October 1st is a good idea. *5 if you have a follow-up question. No new questions. *5 if you have a follow-up question. Better World says the beneficiary gets NTA, notice to appear, based upon a very old denied I-130. Is no more in touch with the divorced USCIS wife. How to get copy of that NTA? You can have your lawyers contact the Immigration and Customs Enforcement, ICE. You can also file a Freedom of Information Act request to get all your immigration paperwork, but the NTA itself should be available through ICE. Get a lawyer who does deportation cases, have them involved. They would know better than I would. *5 if you have a follow-up question. *5. Okay. Lucky says, my wife is an LPR, lawful permanent resident green card holder. I'm an Indian citizen. I don't have a visa to visit USA. They had planned to process their green card through counselor. They submitted the I-130s in California, where the processing time is 19 months. Priority date is current. Do we need to wait until I-130 is approved? Yes. Until the I-130 is approved, your application hasn't moved anywhere. When do we need to file rest of the documents like affidavit of support? So after the I-130 is approved, the file gets sent to National Visa Center in New Hampshire. They will send your wife actually, all the papers, including affidavit of support, that she must fill out and send back to NVC. Okay. When can I visit USA? Well, until you get your green card, coming to the USA is a crapshoot. It's very difficult to predict. For example, getting a tourist visa. And there is no law that expressly says you can't get a tourist visa if your green card is pending, but it is a very strong admonition against a tourist visa approval. So I think your best chances are after green card, which could be still a couple of years ahead of you. *5 if you have a follow-up question. *5. No new questions, just any follow-up questions on this. Okay. I'm an Indian citizen, came on B2 visa in April 2005, working in Singapore. B2 was approved before I got married. So you became illegal, used my previously approved B2 visa to join my husband. In 2007, I had a child. You stopped working about 2 years ago. Oh, you didn't become illegal. You got an H-1B sponsorship, but you stopped working for 2 years. So unless there was a medical necessity for that, they are likely to consider that to be out of status. And you also have a Class C misdemeanor. Okay, well, you got your green card, which is expiring in 7 months. What is the process to apply for US citizenship? Same as everybody else's, N400. You can see, green card can be renewed anytime. I would want you to have a consultation with local counsel wherever you are, just to make sure that that Class C misdemeanor, remember, expungement doesn't mean anything for green cards. Just make sure that the misdemeanor is not really going to be a problem for either your green card or naturalization. So your next step is to have a consultation with deportation counsel. Okay. And once they say that it's all clear, green card is not going to be in trouble, I would just apply for naturalization directly. You can, when you are qualified to apply for green card under both 5-year category and 3-year category, I mean your naturalization, you can choose either way. It's probably easier, lesser documentation for a 5-year green card. I think your question about whether you're going to get naturalization or whether or not you're going to get a renewal of your green card, it all depends upon whether the crime has in any way any immigration implications. So normally misdemeanors are not a problem, but I have seen cases in state law where they call something a misdemeanor but it's actually a felony. So misdemeanor C sounds like it should not be a problem, but until somebody who's knowledgeable about that section of the law, or at least has reviewed it, unless they comment, I can't really tell you much about it. We are just guessing. Okay. *5 if you have a follow-up question. *5. Samir, Immigration Hub 2014 says N400 is pending for 9.5 months. I want to buy a house. Moving within the same jurisdiction, which is one town to another which falls within the same USCIS jurisdiction. Do you anticipate any potential delay? I don't think the move itself would cause you a problem. Make sure you update your AR11 and make sure you call the customer service to update your address, as well as the local office if your file is in N400 local office. So I don't see any other potential delay possibility. If you were moving out of that jurisdiction, maybe. *5 if you have a follow-up question. *5. Okay. Hux 341 says EB5 investment is going to increase to 1 million from 500,000. I don't know the answer to that question. It was being proposed, but we haven't seen a draft of the regulations yet. Nobody has. *5 if you have a follow-up question. *5. Okay. Next question is from Better World. So BIA remanded your case back to USCIS. US citizen wife filed I-130. It was denied after 2 interviews, ignoring all the evidence. You appealed to BIA. BIA remanded it back. No update until now. Now we just heard that I-130 was reopened for review upon court order. Do you think they are reviewing BIA order now? Been 4 years since BIA ordered. I don't know the answer to that question, and I guess you went to court over it. Once the court orders, depending upon the language used by the court, government is pretty much stuck with it. They have to respond. Remanded is, I would say it's more good than bad. You wanted to know whether it's good or bad. Remanded is good. That simply means the higher authority, in this case Board of Immigration Appeals, believes that this case was not completely examined. So, for example, if they miss looking at some evidence, BIA can say, guys, you haven't looked at this evidence that was presented and you made a decision without it. We want you to look at the evidence. So it's basically a do-over for USCIS. In my view, it's good news. *5 if you have a follow-up question. Okay. PO Box 8284 applied for 485 using cross-chargeability and waiting for over 15 months for an EB2. How can I confirm that cross-chargeability was applied? Only thing you can do is contact the USCIS customer service and ask them. Just because you got your EAD and AP does not mean that you got cross-chargeability. Normally they don't screw this up, but they can. Doesn't hurt to double check with the USCIS customer service. *5 if you have a follow-up question. Okay. Mitesh says,
I am with company A on H1B. Approval is good to Jan 2022. Company is getting shut down
by the end of this year. So changing from A to B. While H1B transfer is pending or gets approved when I'm out of the country, I would like to visit India and get my passport stamped with H1B using company A's approval, then come back and join B. I think that's a problem. I think if you came back and after a few months join B, that would be okay. But getting stamped for company A while you intend to join company B, I think it's a problem. And if you want to work for both companies, you would have to file an amendment to reduce the working hours for your current company. And you would have to file, probably if the second case is approved, file it as a concurrent part-time H1B. Okay. *5 if you have a follow-up question on this. Once again, no new questions. Any follow-up questions? Okay. Navraj Sid says, I'm a US citizen sponsoring tourist visa for my uncle, inviting him to my engagement ceremony. How many years worth of tax returns do I need to provide? Well, first of all, there is no law that says a tourist visa applicant has to provide an affidavit of support. But they do. I would hold back until the consulate asks for it. And I'm forgetting the number of the affidavit of support. It's not I-864. That's for green cards. There's another one. I want to say I completely escaped my mind. So there is another affidavit of support that you give for non-immigrant visas like B2 visas. It isn't required. And you should grab hold of that affidavit of support for non-immigrant visas. Get hold of that. Read the instructions. Read the form. It will tell you what you need to send. From what I recall, I don't think we need to send our tax returns for those forms. Star 5 if you have a follow-up question. Star 5. Okay. So next question from John, I already answered that. I'm sorry, we don't do asylums. I would not want to comment about this because it's all asylum related question. So I'm sorry, I must decline to answer. I just don't have enough knowledge to answer definitively your question. Next question is from Sarvav. My spouse is on H4EAD. Because of the uncertainty with H4EAD, H1B got processed, approved from October 1st. We are planning a trip in August 2019 and appear for a visa interview under the H4 category. Well, I think that should be acceptable. It's a little confusing, this whole situation. If you were an F1 holder, there is a frequently asked question set by ICE, which discusses travel during the gap. The situation is very similar. I think they ask you to have a visa in hand when you travel out. So can she come back on H4? Definitely. Does it affect her H1B? I don't know the answer to that question. My guess would be it should not. But can I guarantee it without looking at the law? I cannot. So I know that for F1s traveling during gap, the law is if your H1 change of status, etc. is approved and then you travel and you come back before October 1st, your H1B doesn't get disturbed. Okay. So I would say something like that would apply to her, probably, because there are some variations. She doesn't have a visa stamp on her passport. But let's say she gets an H4 visa and she comes back before October 1st. I'm assuming that you must have filed H4 to H1 change of status already. On October 1st, that would become effective. So I don't think it should be a problem. Okay. And she can continue to work on H4EAD when she comes back. Does she have to appear for another visa interview before switching to H4EAD or H1B in October 2019? Or can she just fill a form W2 and switch to H1B? W2 is a IRS form. I think you're talking about I-539, but I-539s don't apply to these situations. If she's already received a change of status, she should be able to start working on H1B on October 1st. But please have her lawyers confirm it. I would have to review the law and see how it applies in the H4 cases. I know it works well in F1. Star 5 if you have a follow-up question. No new question? Follow-up, please. Okay. Folks, just to let you know, I won't have time today for new questions. I barely made it to this call. I will have to stop after I answer the posted questions. We are quite swamped with a bunch of things that I need to do. So I won't have time for new questions today. And the last question for the day is, I am on H1B, I-140 is approved. Disability of kids can expedite green card. No, there is no such provision. There is no provision to hasten your green card because of a child's disability. Sorry. Star 5 if you have a follow-up question. No new question. Follow-up question. Okay, very good. Folks, I'll talk to you again in 2 weeks. Just remember to post your questions if you want me to answer them. I may not always have time to answer new questions like today. Good luck and good talking with all of you. I appreciate your time to join me in this conference. Bye-bye. Every other Thursday at 12:30 p.m. Eastern Standard Time, we host free community conference calls. Everybody is welcome to join. Some people post questions ahead of time. You can take membership in our forums. All of the details are there on our website, immigration.com. You can take membership ahead of time, and it's instantaneous. It happens right away, and post your questions beforehand, or you can just log in. The phone number and all are provided: 202-800-8394, 12:30 Eastern Standard Time every other Thursday. We have free apps for both Apple iOS platform for your iPhones and iPads, as well as for Android. Just look for immigration.com, the period dot, and the application should show up.